arise after the presentation, you can certainly reach out to me. But just like the title said, the goal of today's presentation is to walk you through the best practices for handling employee terminations in a way that protects your organization from risks and threats, but also gives the employee who's being offboarded from your organization a feeling of respect and fairness. Terminations, as everybody knows, is one of the hardest things or hardest parts of managing people. But when it's done correctly, it doesn't have to be messy or overly risky. So by the time the presentation ends, I hope to make sure that everyone can understand and define at-will employment, contractual relationships, and implied contracts, and what the differences are. Define progressive discipline and have some good strategies for documentation. Understanding termination risk factors, potential claims such as discrimination or retaliation, best practices for the termination meeting, and then post-termination steps. So after you've terminated the employee, what steps do you need to take? So I like to usually start out with a question, and I know you can't answer me, but many business owners don't know that your business can face a wrongful termination claim, even if the employee technically resigned. So it probably sounds pretty surprising. And it's called a constructive discharge claim. So that happens when the employee feels that they had no real choice other than to resign from the environment because it was either toxic or unbearable. And this can be caused by the employer, the organization, or it can be something that the employer allowed to continue unchecked. So the tricky part is that it doesn't matter whether the situation was actually lawful unlawful, or just perceived that way by the employee. If a claim is made, you're going to be forced to respond and defend your actions. And hopefully by the end of this, you'll have a good way of doing that. So just some examples of constructive discharge situations. It could be repeated verbal abuse, such as, calling someone incompetent or useless. Sexual harassment. So maybe a supervisor or manager says something like, women shouldn't be in charge of money, or maybe you should smile more for the clients. Unreasonable workload increases after making a complaint. So the employee complains about something and suddenly there is a ton of extra work or projects that are put on their plate and they're not offered any help or compensation for it. Revoking PTO and threatening job loss after making a complaint or retaliation for speaking up in general. So in each of these situations, the employee may not be outright fired or terminated by you, but they may feel that the conditions are so demoralizing that they actually resign. And many people look at me and say, well, they chose to leave, but the problem is the law may see that in a very different way than you do, okay? So let's break down the three most common types of employment relationships. I'm sure everybody's very familiar with at will. It's by far the most common type in the US, and it means you can let an employee go at any time for any reason or no reason at all, with or without notice. But just because a termination is legally done in an at-will situation, it doesn't mean that a claim can't or won't still be filed by the employee. So you got to make sure that you're documenting everything. We're going to talk a lot about that. Contract employment. This is pretty standard. So when you're hiring someone for a defined period of time, it specifies you typically have a written contract with them. It specifies your project, your terms of compensation. And typically once you're in that contract relationship, you're bound by its terms. So you can't really terminate at will without risking breach of contract. And then the third one is the implied contract. And this is a gray area because it kind of falls between both at will and contract employee. So it isn't necessarily that you have a signed document with the employee, but it still could be legally binding based on things that you put in writing. So what does that mean? Like offer letters, the employee handbook language, emails or texts. And this is typically most of the time happening in verbal statements that are made by a supervisor. So let me give you an example. We have Maria and Joe. Maria is the employee, and John is the supervisor. And Maria says to John, I'm really happy here and I appreciate all your feedback. With everything I've been contributing, is my job secure moving forward? And Supervisor John says, Maria, you're one of the most valuable employees we have. As long as you keep doing what you're doing, you'll always have a place here. We don't let good people go. And Maria says, that's good to know. I'm just trying to plan for long term. Now, that may seem like a really casual, innocuous conversation, but it could later be used as evidence that the employee was promised job security and that she reasonably believed that she could only be terminated or fired for cause. That is why I always recommend that anything that you have in writing, like job offers, job descriptions, job postings, employee handbooks, that there is the at will language somewhere on that document. And it's really important that consistent use of that doctrine is placed on everything in writing. So let's talk a little bit more about at-will employment. So as we talked about, you can fire or terminate an employee at any time for any lawful reason with or without advance notice. On the flip side, right, the employee can also leave a job at any time or for any reason without giving notice. So it's designed for flexibility on both sides of the table. However, at-will employment doesn't give owners and employers a free pass. You can't terminate someone for illegal reasons like discrimination, retaliation, or whistleblowing. If you're inconsistent with how you apply these policies or your discipline, that can create legal exposure. And state rules matter. While the general principle of at-will employment is widely recognized across the US, Montana happens to be the exception. So in Montana, once an employee completes their probationary period, they're no longer considered at will. Instead, a business owner or employer must show good cause or just cause for the termination. That means all of the burden is on the employer to prove that it was legitimate, it was documented, and there's a reason for ending employment. Okay. Most other states do not have that. However, I do want to let you know the at-will laws are evolving, and New York State has had several instances where it has been introduced at the legislation level. And they would like to limit or eliminate at-will employment in favor of just cause. Now, typically they've been doing this for certain industries and or larger employers, but it is a thing that we should all be thinking about. And if you implement progressive discipline, you will have no reason to fear it if it does change. Okay. The at-will status may offer flexibility, but documentation, and I can't state this enough, is what protects you. So writing things down, having things documented is very important. So let's talk about the risks of getting termination wrong. So if a supervisor, manager, HR professional terminates an employee that violates federal, state, or even local employment laws, the company can be held legally liable. This means penalties, fines, legal fees, and even your business's reputation. These situations typically fall under what's called a wrongful termination case or clause. This can be some examples of this are discrimination claims. So an employee says that they were not let go because of job performance, but because of a protected characteristic like their race, gender, age, religion, disability, and that list is quite extensive. Those are just a few of the protected characteristics. Or retaliation claims. An employee can say that they were terminated after engaging in a protected activity, such as reporting harassment or filing any claim with HR or participating in an investigation, discussing wages. They are allowed to discuss wages. Breach of contract claims. These are where employees believe that they had a written or implied, or remember that verbal, that implied agreement. And this could be through their offer letter, the handbook, or of course the verbal assurances that we talked about earlier with Maria and John. And then of course, constructive discharge. So they're not formally terminated, but in their minds, they are forced to resign because of hostile or toxic work environments. So even if you feel confident that the termination was justified, the employee may still view it differently, and they can and will pursue legal action. So even if it turns out that you were justified in the termination, you will be forced to defend that claim when and if it happens. So what do, right? As business owners, how do we protect ourselves? And it comes back to progressive discipline. Progressive discipline is a step-by-step approach in addressing employee issues. So it gives the employee a chance to understand what they're doing wrong. They can respond to it and correct their behavior. And it shows that your company is being fair and reasonable. And that's really important if things matter later and escalate into a claim. The progressive discipline policy should be clearly outlined in your handbook and applied consistently across the board. So if you don't do it for John and you do it for Maria, that's discriminatory. So there should be no exceptions and no discrimination. Now, there's always exceptions, right? Everyone says, well, what if someone is just totally unfit for the position that they're in? Or what if someone steals from my organization or there's workplace violence? In those situations, there are times where progressive discipline is not utilized and immediate termination is warranted. But today I want to talk about where we kind of go through those processes and that step to get to the ultimate step, which is termination. So the progressive discipline is a smart way to avoid unnecessary terminations, obviously reduce legal risk, and save time and cost on recruiting and training. Everybody knows, when you terminate someone, you now have costs to go out and find someone new, train them, spend time with them, get them acclimated to the culture and what it is their job is. And all of that has a pretty high price tag. If you haven't ever measured that, I strongly suggest that you do. So the rule of thumb is always document what happens. I'm sure everybody's heard, if it's not documented, then it never happened. And I can't state that is true. So true. Stick to the facts. Use some restraint in what you're documenting. So stick to the facts. Avoid guessing. Don't exaggerate. Don't put personal opinions in there. Make sure things are clear, professional, and objective. Okay. Don't include your comments, your personal frustrations. You don't like John for whatever reason. Don't include those comments in there. If there is something that is ultimately impacting morale or performance as it pertains to personality conflicts, absolutely put it in there. Otherwise, that type of stuff doesn't really belong in the record. So here's something I like to tell my clients: write down what happened. A lot of them will call me and they will be in the heat of the moment. They will be so angry and frustrated. And I'll say, write it down, get it all out on paper, include all your comments, your convictions, your personal opinions, just get it out on paper. Once you've had a chance to get it out on paper, run it through one of your AI tools like ChatGPT and use a very specific prompt telling it to strip out any emotion or bias or discrimination, what have you. That typically helps a lot. And what's left after that is a clean, fact-based summary of what happens. So you can use that for a verbal or written warning, performance discussion, or even a PIP, which is a performance improvement plan. So what happens though, and we all, I'm sure, have experienced this, where you go through so many of these meetings and so much of this time, and it's just not working. The employee is just not improving, or they continue to take steps that are breaking policies and things like that. It's definitely a tough spot, and it happens. But the progressive discipline gives the employee multiple opportunities to correct the behavior. And if that in fact doesn't happen, then of course, yes, we move to that next step, which is termination. One of the things I always like to caution is let's take a minute and think about this though before we get to that termination stage and say, have we been consistent and fair with this employee? With each stage, we verbally told them, we wrote up, we gave them a warning, we gave them a PIP perhaps. Is each stage well documented? Okay. And during that documentation and those meetings that you've had with that employee, did you make sure that the employee understood the potential consequences if this wasn't corrected? In other words, Maria, if you don't correct your behavior, you are in jeopardy of losing your job. Okay. Being crystal clear on what can happen if things do not improve is very important. And then making sure you're basing the decision on performance and their behavior, not bias or emotion. Termination should never come as a surprise to an employee if the process was handled correctly. Now, this is important. You want to make sure that as you're kind of going through these stages in progressive discipline, you are putting them in the personnel file. So I want to talk about what belongs in the personnel file and what does not belong in the personnel file. Okay. First of all, personnel files should be in a locked cabinet or within your electronic HRIS system, password protected, or have some other security on it so that unauthorized individuals cannot get access to this. Typically, HR or business owners are the people that have access to personnel files. And it's not just about, organization, right? It's about protecting sensitive information and maintaining legal compliance. So the employee's personnel file should tell the full story of the employee's time with your company, from the day they're hired to the last day they work there, okay? Things that are included in their signed acknowledgments. So maybe your at-will employment, your employee handbook, job applications, offer letters, performance reviews, verbal and written warnings, progressive discipline records, promotions, transfers, compensation changes, attendance records. Those things should all be in the personnel file. What should not be in the personnel file is sensitive or highly regulated documents. These records should be stored separately to protect employee privacy and to comply with federal and state laws. These things include medical records, I-9 forms, workers' compensation claims or injury reports, EEO complaints or internal investigation documents, background checks, credit reports, drug screening results. Mixing this into the general personnel file can create unnecessary legal risk. So you want to make sure that those are stored appropriately and not in the same folder. Next, you want to ask yourself, is there a chance that this could be viewed as discriminatory or retaliatory? Sometimes when you have a person who is, who needs to be corrected, who you have going through this process of progressive discipline, there can be times where that person may also engage in a protected activity, such as making a claim or advising someone that something discriminatory is going on. So when those things happen at the same time progressive discipline is happening, those are very important things to make sure that you're not opening yourself up to this looking as if it is retaliatory. I'm firing them because they made a claim against one of my managers or a sexual harassment claim or what have you. So again, there's a long list of protected characteristics. So you want to make sure that you're running through all those. And they change. I think we've had a couple changes over the last 3 years to what was considered a protected characteristic. So if your reasons for termination are legitimate, you need to make sure you have everything clearly documented and you've applied your policies consistently. Avoid doing anything that looks like retaliation and make sure disciplinary and termination action is strictly based on performance and behavior issues. Bottom line, it's better to take it slow and double check than deal with a claim later. Sometimes dealing with those claims can be very messy and it can at times require legal representation, which of course we all know can be extremely expensive. So once you've completed that analysis, it's time for the supervisor or the HR person or whoever is kind of ultimately making this decision to evaluate the overall risk. So could the decision be misinterpreted as retaliatory or unfair? Is it emotionally charged? Has there been prior conflicts? Is the documentation in the file too thin? If there are cases where you feel like maybe there could be some concern here, there are some remedial measures that maybe you can think about. So offering the employee severance pay or a severance package, this can kind of ease the separation and show good faith. Provide a neutral or positive job reference, making them feel like, okay, I know I'm getting fired, but at least I have something to help me look for something new in the future. Maybe let the employee know you won't contest their unemployment benefits, okay? The goal of these measures is to reduce legal exposure and really part ways with that employee as smoothly as possible when possible, okay? So when it is time to finally sit down and terminate this person, you want to make sure that you're doing it in person and having a face-to-face conversation if at all possible. This is my number one preference. So if you can do it face-to-face in person, that's the best way to do it. You can certainly also use a secure video conferencing platform, but the key is direct communication. It shows respect and it allows the employees to kind of process the information that they're being given and allows them to ask questions, okay? Who should lead that discussion? It can be the employee's supervisor, an HR representative, or both. This isn't an easy conversation and it can get emotional and really stressful. So making sure you are staying calm, clear, and professional, even when the employee becomes visibly upset or emotional. Stick to your facts, maintain a respectful tone, and make it a clean break. Let them know the decision is final and guide them through what happens next. So returning equipment, when is their final pay? What does COBRA look like? It's also smart to have a witness present. Usually that can be like another manager or someone from HR. It not only helps protect you, but it protects the company as well, okay? So the termination should really be handled professionally and compassionately with empathy. The way you exit an employee speaks volumes, not only to that individual, but to the rest of your team as well. Now let's talk about choosing a witness. Ideally, the person should be neutral and uninvolved, someone who's trustworthy, but someone whose presence won't raise questions later about bias or motive, okay? So who makes a good witness? Maybe a manager from a different department who isn't personally connected to the situation, an HR person who has no direct involvement with the employee's performance or discipline, but most important, someone who can remain calm and professional, even when things get emotional. If you're concerned about safety or a heated situation or a especially extreme emotional reaction, you might want to choose a witness that can help maintain order, like a security guard, or someone who has a calm but confident physical presence. And it isn't to intimidate the employee, but to ensure everyone feels safe and supported. Most importantly, though, make sure the witness understands their role. They should not be participating in this conversation. There's no comments, there's no coaching, and there's no reaction. One important thing is to body language and facial expressions. They can't make any. It may make the employee feel judged if the witness is, making facial expressions, or make them feel uncomfortable and hesitant to speak or ask questions. If the witness is asked to take notes, make sure that they are taking objective and fact-based documentation and making sure that they're not including any opinions or assumptions. Think of the witness as a quiet observer, someone who can later verify what happened, but who doesn't necessarily influence the direction of the meeting itself, okay? How you do a termination is just as important as what you say, okay? So please do the termination directly, in real time, and with respect, okay? Here's what to avoid: sending a termination to someone's home before speaking to them. Never, never, never do that. Email news without any prior discussion. So, hey, hi, here's an email, you're fired, and they didn't know it was coming. Don't relay the message to someone else, like a coworker or a lower level manager. And try wherever possible to absolutely avoid texting a termination unless there's truly no other options. This can be the most difficult thing a person experiences in their whole working life. And to receive news of a termination electronically or without the proper or without doing it the proper way can feel impersonal, cold, and humiliating, and ultimately make them feel suspicious as to why they're really being terminated, which can open a can of worms to legal claims. Of course, I know I said, don't text them. Don't do anything that's impersonal, but there are exceptions to every rule. HR is never just black and white. There are gray areas. I have national clients that operate in very remote areas, or maybe they have large mobile workforces that don't report to an office, or have inconsistent access to technology. So in those situations, an email or text may be the only viable way to reach someone quickly and document the communication. But the goal should always be, even in those situations, to speak to the employee by phone or video wherever possible. So that is preferable. The person leading the meeting, whether it's the supervisor or the HR person, should be clear, direct, and fact-based. Okay, avoid language that can be misinterpreted or challenged later. You know, a lot of people say, well, why do I have to give them a reason for my termination? I'm just going to say you had poor performance, or your attendance has been a problem, or you've been insubordinate, and that's why we're terminating you. And those are all valid reasons. I'm not saying that they're not valid reasons, but giving someone actual examples of what you mean by that can really help a claim in the future. So something like, you know, over the last 90 days, you missed 6 scheduled shifts without calling ahead. The absences were documented on specific dates, and we've had 2 formal conversations about the issue, which were also documented in writing. If you can give the employee copies of those documents as you're sitting there in the termination meeting, that would be great, because that is solidifying that you truly are making this decision based on documented facts. It shows transparency, and it reinforces the decision is grounded in documented history, not a spur-of-the-moment reaction. Now, a lot of times there are exit forms that require signatures. Ask the employee to sign them during that meeting, and if they refuse, it's okay. But make sure you're writing on those forms, employee refused or declined to sign, and then sign and date those forms as well. Make sure you're communicating the effective date of the communication, information about final pay, any applicable benefits continuation, how to return company property, and who should they follow up with in the event there are additional questions. Okay. Structured and facts-based messages really prepare you and the employee in the case where the employee is contemplating a claim, or maybe they do make a claim. Okay. New York specific requirements. I believe everybody on the call is a New York State business. New York State does require us to give a termination letter that includes the exact date of separation and final pay details. They also require us to give the employee a record of employment form, which is a form I as in igloo, A as in apple, 12.3, and that advises the employee of their right to apply for unemployment benefits, regardless of whether you plan to contest the claim or not. So following all of these steps ensures the termination is respectful and lawful. Okay. If you're operating in an at-will state, refusing to give a reason for termination is usually not the best move. It can raise red flags. It can confuse the employee, blindside them, and make them think that, hey, maybe they are doing this because I made a claim, or because I'm, 70, or because of my race or disability. And typically those claims do come out more so often when a true documented reason for termination is not given. And in some states, employers are legally required to provide the reason for termination and a general explanation. Now, keep in mind, you don't need to go into deep detail and rehash every single issue. Focus on the core issues like ongoing attendance problems, performance concerns, violation of company policy. Be factual. Give the specific examples, okay, that have been documented. Give them copies of that documentation. And then be professional and neutral. Avoid blame, judgmental language, or emotional commentary. So, for example, we might say, we've discussed several concerns over the past few months regarding missed deadlines and lack of follow-through on key tasks. Despite multiple conversations and written warnings, we haven't seen the necessary improvement. At this time, we've decided to move in a different direction. Okay. This is an honest explanation without being harsh, and it gives the employee a clear reason for the decision. The bottom line is clarity helps everyone. It doesn't just help the employee, it helps you and it helps the employee. So the best approach is to make the termination effective immediately if you can. So release the employee right away from their duties after the meeting ends. It's a clean break. There's no lingering tension, and it minimizes the risk of negative behavior or disruption when that employee goes back out on the floor. I know immediate termination isn't always practical because sometimes, maybe there's project that needs to be completed, or maybe you're expecting that employee to train, replacement, or what have you. But when the termination is able to be immediate, handle it with discretion and empathy. Okay, don't humiliate the employee. Don't make them box up all their stuff and do the walk of shame past their coworkers. That kind of exit doesn't just affect the employee; it affects the people that are still sitting in your organization and makes them fear that they might be treated in the same way. I always like to choose timing very carefully, so I suggest doing things at the beginning or the end of the day to reduce visibility and make it a more respectful departure. Make sure you're assessing if there's any security needs or concerns, and make sure you are escorting that employee out of the organization. Okay. If you can't do it immediately, if you have to give advance notice because of for some business reason, make sure you're restricting that person's access to sensitive data and systems, client records, and admin privileges, things like that. When employees know that their days are numbered, there are times where they tend to, I guess, do things maybe that they wouldn't normally do. And so limiting their access to sensitive information, turning off their administration rights is pretty important. Making sure you're supervising them at a higher level during the notice period, so that they're not doing anything that is, I guess, destructive. So after the termination is done, your job is not finished. So make sure you're taking steps to prevent retaliation, sabotage, accidental security issues once the employee is let go. If you can notify your IT provider before you start having that conversation with the employee so that they're turning off access to systems and platforms while you're terminating that employee, that is recommended. Collecting key cards, access badges, company laptops, phones, equipment, and making sure that you're disabling all login credentials if the termination is immediate. And taking these steps doesn't mean you're assuming the worst of the employee. You just want to be prepared and protect sensitive business data, client data, and ultimately your infrastructure. And handle personal belongings with care. If the employee can't go and pack up their stuff, offer to pack it and ship it to them using a bonded courier delivery service. There are times where, if I have an employee that has an office, I'll ask them to list their personal belongings on a sheet of paper just to make sure that we're not missing anything. And be respectful and thorough in handling their personal property. And then finally, most importantly, communicate with the team that's left. Okay. Don't leave people that are still employed there guessing on what happened to that person. It's just going to create gossip and all sorts of challenges. So make a professional announcement that advises that the person is no longer with the organization. You can say, quick email as of today, whoever it is no longer with the company. We wish them the best in their future endeavors. If you have questions on their projects or responsibilities, please reach out to and list a new contact. It creates transparency and a healthy culture. It assures your team that everything is okay, and it keeps workflows from stalling out. So how you handle the termination and the moments after the termination are just as important as how you deliver that message to the person that is being terminated. So it reinforces to your team your company's values and professionalism. So at this time, that does wrap up the presentation. If there are questions, and if anyone wrote anything down or you want to talk through anything, I would be happy to answer any questions that you may have.
I actually had a question.
Sure,
So if our businesses that are members were to need help with this kind of offboarding or onboarding, do you have your contact information that you can give so they can get in touch with you? Because it leads to the question, if if they were working with Envision Benefits Group, would you be able to handle the termination for them?
Yes.
That's my question.
Yes. So we do that a lot for our clients. We do go on site and handle the termination. We will handle all of the write-ups for the progressive discipline. We will pretty much handle the beginning to the end, either with the client or if they prefer not to be involved, we will do it for them. And yes, my contact details are at the end of the presentation. People can certainly reach out. I always love questions. So yeah,
Okay,
absolutely.
because it's kind of scary, like all of the things an employer has to know, what to say, what not to say, you know?
Yes,
I mean, it's a little scary because if you say something wrong, not trying to be malicious in an exit interview, and it's
mhm,
taken wrong, you could have that suit brought against you or that complaint. And so it's just scary to have a legitimate HR, a dedicated HR company that can do that for you, I think is very beneficial. So
absolutely. Thank you very
yeah.
much. That's a good
Oh,
point.
all right. Let me just check and make sure we don't have any other questions being raised here. Let me see. Okay, any Q&A? We don't see. Let me just make sure. Okay, if no one has any other questions, I guess we're going to wrap it up. This is being recorded, this presentation. It's going to be sent out to our members that are joined here today, as well as the link will be included in our weekly newsletter that's going to go out at the end of the week, which is, and if anybody does want it sooner, just let me know. I can send that email over. But I'd like to thank you, Kristin. Thank you so much for presenting today during the virtual Lunch and Learn. This series is sponsored by Milestone Financial Advisors and Envision Benefits Group. So
Thank
thank
you,
you.
Christine.
Have a great day, everybody.
Bye, everyone.
Bye.